Careful on your answer.
No, Your Honor.
That's not what you're saying to this court, because I really hope you're not.
No, Your Honor.
I think what's in there and it's sanctionable.
Good morning, Your Honor. Olivia Camaro appearing on behalf of Plaintiff Pierce Lake Village Association.
Good morning, Your Honor. Travis Gagnon appearing on behalf of defendants James E. Heaton Trust and Tenant.
Your Honor, can we address a housekeeping matter prior to getting into the motion, please?
What is the housekeeping matter?
So at the February 20 hearing that we were at, it was relayed to the court that defense counsel represents all defendants, and I wanted to confirm that defense counsel does in fact defend all defendants. He advised the court that he was planning on filing a motion to dismiss the Ellen Trust on the basis that she had no alleged interest, and that motion has not come through, and their captions seem to state that they only represent the trust, the Heaton Trust, and the tenant. So if that's the case, I'm going to need to default the Ellen Trust, but I just want to confirm.
We filed an appearance on behalf of the James Heaton Trust and Tenant only. It is still our position that the other trust has no ownership interest in the unit that's in question. And again, it's not that I won't file a motion. Our motion that is teed up today is to adjourn the trial, which would seemingly bump the motion hearing or motion filing deadlines as well. That will likely be a part of the motion that's filed at that time.
I don't know if that's a housekeeping matter or not. I mean, if you believe that they're not representing them and you want to file a motion for a default, I think you need to file your motion.
Understood, Your Honor.
All right, Mr. Gagnon, it is your motion, sir.
It is. Thank you, Your Honor. Hopefully it's a simple motion here. On April 10th, we had a hearing in front of this court, and we had set the date for a non-jury trial for May 5th. At that time, only counsel was required to be present at the hearing, and counsel checked their schedules, and it was clear of any conflicts for the May 5th deadline, or for the May 5th trial date. Within that following week, I was able to meet with my clients, explain to them what the next steps were, and that there was a trial that had been set. It was only at that time I was informed that there had been a long-standing travel that had been planned by my clients, who are not only just named defendants here, they are representatives of the trust that owns the unit, but also key witnesses in the trial, that they would be out of the country, and I think it was until May 18th. Given that it was a 3-week lead time or a 2-week lead time at that point, they were not able to cancel their travel. And I, that same day, reached out to chambers and counsel to try to see if we could set another trial date, whatever the soonest available trial date was, following their return to the country, May 18th. We were given June 2nd as a potential date and told that we should stipulate. I communicated with counsel via email and phone calls several times. I wrote them that day. I wrote them the following week. A couple of times in follow-up. I left 2 voicemails, and I never heard back from counsel. So without hearing anything further, I filed this motion to adjourn the trial date so that I could have my key witnesses as a matter of due process here, so that we have are able to present our defense. In the response, which is the only response that I've heard back, whether email or formally or informally, they cite MCL 600. Got 5735, 2 different sections. These are for summonses, and
I know.
So
I'm well aware of that, and I'll get to it when I hear their response, because I think the response is frivolous in a lot of ways.
Yeah, and I will just point out, Your Honor, my last thing. We've already extended deadlines in this case before at plaintiff's insistence. We had our hearing in March that was scheduled. Plaintiff reached out and asked for a stipulation to move that date, which again is far beyond 10 days from the filing of the complaint. We did stipulate to that and moved it to the April 10th date to cooperate with counsel. Now we're being told that it's not a matter of discretion and that there's no power to move beyond based on this good cause. So that is all I have, Your Honor. Our request is that we move the trial date to June 2nd, or if counsel or plaintiffs are unavailable on June 2nd, we're happy to find another date that works where everyone is present.
Response.
Your Honor, MCL 600.5735 sets the dates that the summary proceeding must occur after the issuance of the summons.
How long have you been doing summary proceedings? Because what's the date of that statute?
It's been effective since, it's at least amended since 2004.
Correct. And in 2020, particularly Supreme Court Administrative Order 2020-17 changed that, correct?
I would need to verify, Your Honor.
Yeah, you should have looked at that before you filed this response. Go ahead.
Your Honor, we largely rely on our response to the defendant's motion.
Yeah, but I've got questions regarding the response because what you put in the response, it seems to me to be frivolous regarding an argument for a motion to adjourn the trial date. You're indicating that the court doesn't have discretion, that there's got to be a hearing without any analysis of the original statute that provides for service and a hearing date from within the 3 to 10 day range. But that's when trials weren't held in the manner that they're held right now. And so I don't think that you necessarily, if you want to try to explain what all of this that's in here, then you might want to do so, because I consider many of the arguments that you make here absolutely frivolous and not taking into account the statutory and court rule changes that have occurred regarding summary proceedings.
Respectfully, Your Honor, again, our position is that the statute places a limitation on the adjournments and
give me the court rule. By the way, court rules will supersede statutes on procedural matters. That has always been the rule. So give me the court rule that does not give this court discretion to adjourn this trial.
I mean, Your Honor, under MCR 2.001, the court rule yields to the statute.
On procedural matters?
The language in 2.001 specifically states that the rules in this chapter govern procedure in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan, except where the limited jurisdiction of a court makes a rule inherently applicable, or where a rule applicable to a specific court or a specific type of proceeding provides a different procedure. Our interpretation of that specific type of proceeding provides a different procedure, read in conjunction with the Summary Proceedings Act, which provides...
Be kidding me. Read the first sentence again.
The rules in this chapter govern proceedings in all civil proceedings in all courts established by the Constitution and laws of the state of Michigan.
That's it. The rules govern the procedure. So why didn't you, and also the rules do require where somebody reaches out to the opposing side that there is to be some type of either concurrent or not concurrent in a motion that's filed or a request. So why didn't your office respond to defense counsel's request? I'm not saying what the response has to be, but the very fact you didn't respond.
Yes, Your Honor. So while Mr. Ganyu, and I apologize if I misstated that, when he called me, I was in a client meeting, and then the email had already come in that he was moving to adjourn it. And so I didn't have the time to give him a call back and explicitly state that we weren't going to proceed with concurring, but my understanding or my position was a non-response is the same as not.
No, it is not. That cannot be your response. You're going to tell me when opposing counsel reaches out to you, even if you don't agree, that you have no obligation to respond? Is that what you're telling this court?
No, Your Honor. I was intending on originally giving him a call back, but the motion had already came through. I was in a client meeting when he called me.
Your Honor,
You're saying there wasn't a time between his original contact with you and the filing of the motion that you had no way of reaching back out via email otherwise to him? Is that what you're representing to this court? Be careful on your answer.
No, Your Honor.
That's not what you're saying to this court, because I really hope you're not.
No, Your Honor.
You have previously adjourned dates in this case, correct?
Correct, Your Honor.
And you sought the concurrence of defense counsel to adjourn those dates, correct?
Correct, Your Honor.
Then explain to me why you would not show the same courtesy.
Your Honor, we have shown the same courtesy. They also asked for 2 specific adjournments. And in this scenario, the client wasn't willing to give another stipulation to adjourn. We recently received body cam footage of recent calls out to the unit, and
Did that get filed with your response?
no, Your Honor, we actually received it via FOIA request yesterday. And so I was able to watch the body cam footage of what the noises sound like, which really puts into perspective the disturbance that this has caused the neighboring co-owners, which helped me understand why the client was not willing to allow me to stipulate to adjourn.
When did the supposed noises and everything occur?
The body cam footage that I received yesterday, I can give you the specific dates if you could give me one moment, Your Honor.
Yes, please.
So one of the body cam videos is dated 3/10/2026.
310?
Yes, March 10th. The other 3. The other 2 of them are dated 4/13, and then there's one on 4/15, excuse me.
Daniel, you know anything about those?
I don't. I am happy to look into them, but I have not seen any of the body cam footage.
I just
Or-
received them yesterday, Your Honor.
Back to your motion. Did you even, I mean, I'm going to ignore your section 3 regarding the court rules and general discretion not overriding the Summary Proceedings Act, because I quite frankly don't think you know what you're talking about, because you haven't gone and looked at 2017, which changed everything. You also have not gone into looking at the way in which summary proceedings are now handled, and that they were specifically overridden by the Supreme Court regarding certain procedural issues, and then incorporated within the court rules that you say don't override particular statutes. And that's just wrong. I can't, it's just blatantly. And obviously, doesn't make any sense to me. If there are issues, certainly, that regarding the defendant's conduct that you become aware of between the time of a trial date and the time of the setting of that trial date, much like every time, and obviously you don't know how this court works. If you filed a request for an emergency hearing on it, this court would do everything to accommodate that. So if there are issues that are involved between the time of the trial date and that, court will address it. But in that regard, we don't practice law here in Washtenaw County by sandbagging. So if you've got evidence of something that is going on, you present that to opposing counsel, see if the resolution can be worked out. If it can't be worked out, you contact my office, you file a motion. Much like what happened here, this court will accommodate it within its schedule and get you in to address whatever the issue is. We don't practice this way here, certainly not in this court. I am going to, for the time being, ignore this very poorly researched response. Quite frankly, I think what's in there and it's sanctionable. And I'm going to decline at this time to do that. I will take my request, because it's not going to be defense counsel's request. The request for sanctions, I'm going to take that under advisement. So you need to understand, counsel, that doesn't mean that I will not. But I'm not going to at this point. I will also not award to defense counsel attorney fees and costs in this case, but I am going to adjourn the trial date. And I'm going to make it very clear, counsel, so that if you want a written order to that effect, then I'll give you a written order. I don't think it requires a written order. That if there is a circumstance.
Right here, this is where everything flips. The judge is basically saying, you didn't just make a weak argument, you ignored how the law actually works today. That's a serious problem in court. When a lawyer relies on outdated law without checking updates, it can destroy credibility instantly. And now the judge is starting to question not just the argument, but the preparation behind it. Let me ask you, do you think this was a simple mistake or a major legal misstep?